as the wheel shows there, although this conference is focused on privacy laws, we're talking about AI breaches in relation to consumer and competition laws, cybersecurity. So in the financial sector, every regulator has issued quite onerous cybersecurity obligations. So we see in the US and in other countries actions being taken for data breaches and loss of personal information, not under privacy laws, but under other regulations. Anti-discrimination laws, which Sophia has mentioned, negligence, duty of care, work health and safety laws. We see in the US already actions arising out of technology use in relation to discrimination in relation to employee applications, and also I can see issues arising into its use in the workplace as well. So it's much wider than just privacy regulation that directors and organisations need to be mindful of. So key directors' duties I wanted to touch on today are the duty to act in good faith and the duty of care, skill and diligence. So both in the UK and Australia, I've set out the sections there. So the first one I wanted to start with is what I call the duty of good faith, and so that is that directors must exercise their powers and duties in good faith and in the best interests of the corporation. So breaches in relation to AI systems here are that it requires directors to be informed about the subject matter of the AI, and they need to rationally believe their decisions are in the best interests of the company, having properly considered the potential impact of those decisions. So directors knowing that there's systems being put in or being oblivious to it is not going to cut it. Now, for most large organisations that have sophisticated risk management and governance systems, in my view, it shouldn't be Section 181, or Section 172, I should say, because we're in the UK. It's more likely to be Section 174 under the Companies Code. So this is whether they've exercised reasonable care, skill and diligence. Now, the issue here is the risk management framework and the systems that have been put in place. So in Australia last year, we had a case brought by our corporate regulator for a systemic series of data breaches from a financial services company, and they'd taken too long to put in their remedial measures, so nothing to do with our privacy laws. And they were done as a financial services holder with a provision that applies to the financial sector and insurance companies, etc., for inadequate risk management systems. So this is the critical issue for directors and organisations going forward. The integration I see of, if you're cybersecurity, the cybersecurity person comes along and says you need a cybersecurity plan. The privacy person says you need a privacy plan. AI, now we say you need an AI plan. And it's making, I think, boards very reactive in a situation where it needs to be far more strategic. As we keep hearing today, technology is a tool. The purpose of your business is your business. AI is an enabler. It's going to, create massive innovation and change. But as the other word we keep using in this context is, it also amplifies your risk as well. So we've got some information here from a survey that was done just late last year by the Bank of England and the FCA, who's the regulator here for the financial services, on machine learning in UK financial firms. So 3/4 basically of financial companies in the UK are already using machine learning. So this isn't something that is going to happen, it's already happening. what I find extraordinary is, although the survey report says that just over 60% use their risk management process to manage the machine learning process, it means that there's at least a third who are not using their risk management framework and model for their machine learning and that AI systems. So that is a red flag. If you've got reporting systems going up to the board, but it raises the issue, and this is what I see all the time, that the boards aren't really getting the information that they need to inform them to make the decision, but they're actually responsible for that. So most of them have in place data governance. Now, this is an interesting issue for me because data governance, I think, as it's understood in a lot of these organisations where you're so reliant on having accurate and reliable data for your AI, your machine learning, for any system that you're using, it's focusing on the data sets, and that's absolutely fundamental. But as most of us know, organisations really aren't very good at disposing of data. In fact, many of them don't dispose very much or pretty much nothing. And that's a huge risk. So we talk about data being of enormous value and data-driven technology, but the reality for most organisations is that at least half the data they're holding is rot, redundant, outdated, trivial data. And that is a huge risk in itself, not from running an AI system, but in the event of a data breach or in relation to, you know, my background as a litigator, e-discovery and inquiries and the volume and the cost of that. So when you're talking about data governance, is it just over the data that you want to use and extract value from? It needs to actually be enterprise-wide. So that's an interesting survey. So to highlight the issues of cases, so we've had the American cases, which I think are really interesting because when you look at the technology that's being used and then you look up the technology companies that are cited in the complaint and you look at on their website of all the global companies, including state government agencies in the state that I come from in Australia, that are putting this good technology to use, it goes to demonstrate that organisations need to be really careful about, ensuring that they're not discriminating and understanding how it works. So in Australia, a few years ago, we've had fines against two of our four largest banks, as you can see there, one for $1.3 billion and one for $700 million. They were for breaches of the anti-money laundering laws, so we're back in the financial sector. It was front page news. They're the biggest fines in Australian corporate history, but at their heart, they're technology integration failures. And I think they really sound a warning bell, but we haven't really talked today about things like model drift. The title of this conference is Who's Watching Me or You, but I would say who's watching the watcher. So we talk about having a human loop. We talk about the need for checks, but actually who's checking the checker? How do we actually know? So these are some of the things that boards really need to be grappling with.